Hello everyone, a very warm welcome to all of you. So today is Monday, I am Drishti, and before we get started, could you guys please comment in the chat box and let me know whether I'm audible or not? Could you guys comment in the chat box and let me know whether I'm audible or not? Okay, let's get started. Right, so today we are going to discuss a couple of very important topics which are important from your prelims as well as mains point of view, examination point of view, right? So these topics were in news due to one reason or the other. We are going to discuss some very interesting topics and some very sensitive topics, right? So before we get started, I'm going to give you your Seize the Mains question for the day. So Seize the Mains is the initiative which we started a couple of weeks back, right? Daily, as we proceed in the week ahead, we give you daily a question based on the topics that are discussed subject wise per day, and you can write the answers for the same and post them on our website, the link to which you can find in the description box given below, right? This answer will be evaluated by our team of experts entirely free of cost, and with the valuable feedback you receive, you can improve your answer writing, and hence you'll be able to score better marks in your mains examination, right? So the question for today comes from forms the part of your GS paper 2, and it is related to the bedrock of polity and constitution, the basic structure doctrine, right? So the question is, the basic structure doctrine through past 50 years has served as most important tool to strengthen the democracy and keep the spirit of the constitution alive, right? You have to answer again, you have to explain it, you have to answer it in round about 250 words, and the maximum marks for the question is 15 marker, right? So basic structure doctrine has been in news due to n number of reasons, and the bedrock is Keshwananda Bharti case, as we all know, and then there are a couple of other cases that follow. So you have to mention the studies, the case studies, important case studies, and begin your answer with the introduction, what the basic structure doctrine is, give the case studies, and a couple of things we are going to discuss why this was in news. Also, please try to inculcate as many as multi-dimensional points and try addressing all the parts of the question, right? Now let's see what the index for today is. So we are going to discuss the basic structure doctrine. Why this was in news? This was in news because Supreme Court recently gave a verdict and they upheld the amendment that were made through 103rd Constitutional Act amendment, okay, constitutional amendment, and Supreme Court recently has said that the reservation which has been given to your economically weaker sections does not breach your basic structure doctrine of the constitution. We are going to discuss it in very detail, what all aspects are covered through it, popularly what we call Indra Swahane case or the Mandal Commission report. We are going to discuss that. Then there has been a continuous rage about the number of rape incidents that have been increasing in the country, and from there Karnataka High Court recently has brought up this debate about the age of consent for adolescents. So adolescents, the age itself is a very tricky one. You are somewhere between an adult and a teenager, so that whole process while you're having consensual sex at that particular point of age, whether it is termed to be rape or not, what all provisions are covered under POSCO, right? And how does this hamper our judicial system? What all problems have been arising? We are going to discuss that, right? Then there has been a practice of delivering seal covered affidavits in the Supreme Court whenever the issue rises, whenever there is a issue which concerns the national security of the country, what is the issue, how the government has been using it to find a loophole in the court's proceedings, also what all what all repercussions it brings for the other party, we are going to discuss that in detail. Okay, I think this is a very new topic which we haven't discussed till date, right? So seal cover affidavits, there are provisions in the foreign countries, what they do, how they tackle with it. So we are going to discuss this in detail, right? Let's get started. So first topic for today is Supreme Court recently upheld 103rd constitutional amendment which introduced a 10% reservation for economically weaker sections. They introduced a 10% reservation for your EWS quota. So Supreme Court recently has upheld the verdict, and they have said it does not, I repeat, it does not hamper or does not violate the basic structure doctrine of the Constitution, right? Now, where the issue arose? The whole issue arose when the critics said that the act, it breaches your basic structure doctrine of the Constitution by excluding the other categories of marginalized people, which include your socially and educationally backward classes, OBCs meaning other backward classes, SCs meaning scheduled castes, and STs scheduled tribes from the scope of EWS reservation. ठीक है, इकोनॉमिकली वीकर सेक्शन वाले में से if they have excluded these many categories of people, and critics have believed that it has been in direct conflict with the basic structure doctrine of the Constitution. Right now, 103rd Amendment Act की बात करें, so the Parliament amended the Constitution of India. 103rd Constitutional Amendment Act was passed in 2019. In 2019 it was passed, and Article 15 का 6th part was inserted, where up to 10% of seats they may be reserved. Again, it's not mandatory, they may be reserved for EWS for admission in educational institutions. Such reservations, they will not apply to minority educational institutions, because government does not interfere in the educational practices of minority league. ठीक है, then again with the Article 16th part 6, this was inserted, and it permits the government to reserve up to 10% of all government posts in EWS quota. ठीक है, government post as in the government job vacancies, it reserves there, right? Now, if we talk about reservation for EWS over and above 50% cap, so whole issue came out in Indra Swane versus Union of India, popularly known as the case study of OBCs. ठीक है, other backward जो classes हैं उनके लिए this came out, right? Also popularly known as the Mandal Commission case. Here, the Supreme Court ordered that the total reservation should not exceed your 50% limit, and here critics believe that 50% ceiling is constitutional requirement, without which the structure of equality of opportunity will collapse altogether. So this has been a continuous point of contention. Now, what court has said is, court has opined that reservation for economically weaker sections over and above 50% cap does not violate your basic structure doctrine. Ceiling by itself comes under the articles, Article 15 part 4, Article 15 part 5 and Article 16 part 4. Again, this forms a part of affirmative action. Now, affirmative action is, there was an article in Hindi recently where affirmative action was the key word. Now, what affirmative action means? Affirmative action means when government frames a policy, frames a sort of reservation policy or a beneficial policy for a particularly marginalized section. That could be marginalized on the basis of religion, region, caste, sex, gender, color, etc., etc. There could be n number of categories in it. When government forms a reservation policy where special benefits are given to this particular society, particular category of people, which helps them to come at par with the mainstream population, mainstream civilian population. So there, that term, that whole special scheme comes under your affirmative action. Now sealing by itself is not inflexible. Now on the time span of reservation, court has opined that the reservations must have a time span. Even when the reservations were introduced by Dr. B.R. Ambedkar, so they were supposed to be prevalent in the society, to be given in the society for a particular time frame, but with due course of time, every time extension was given and they were extended for a couple of years altogether. Now even after 75 years of independence, we have not been able to come to a conclusion and the reservations are still going on. So court has said that they must come with a timeline. Also, this whole policy of reservations for keeping certain seats reserved for certain categories, this needs to be revisited in the larger interest of the society, and it forms the basic part of transformative constitutionalism. Okay? So transformative constitutionalism is a burning topic that has been in news from past couple of years, and the Supreme Court, the whole judiciary itself has been pushing for it, so as to come out of the age old practices which we have basically inherited from British era. Okay? So this has been the line of action for a couple of years now. Now there have been a couple of arguments which have favored your economically weaker section quota. And what are these arguments? So it is being said that the quota is progressive as it is it includes the society as a whole. It covers the categories which do not come under your SC, ST, OBC categories, and it helps people to uplift from the lower strata of the society and come at par with the mainstream section. Now it also addresses abysmal section. Not all people who come under general category are well off. Okay? So people who come under general category and they struggle with the economically and socially backward sections, it addresses those sections of the society as well. So hence EWS quota should be upheld. Then there was a particular case study called Ram Singh versus Union of India, which came in 2015. Here the Supreme Court, it asserted that social deficiencies may exist again beyond the concept of caste, which can be economic status, gender identity as transgenders, etc., etc. So Supreme Court itself has asserted that there are sections in the society which are beyond OBC, SC, ST, etc., which needs to be taken care of and their problems needs to be addressed. Okay? Then this wholly solely covers the quota for poor policy, and this needs to be addressed altogether. Right? Now there have been, again, with every argument, with every burning topic, there are arguments which are in favor and which are in against. Now there are a couple of arguments which come against EWS quota. Now there is no particular criteria. EWS basically works on economic criteria, but there is no fixed way of determining what is the economic based criteria for people in India, because even in day-to-day lives we see people very easily get fake certificates, fake income certificates. Also people who are self-employed, for them to show that their bare minimum earnings are way below the BPL line is very easy. There are a lot of loopholes. So this does not necessarily prove to be a right method. Then determining economic backwardness, what are the criterions? There is no fixed measures. We don't even have a holistic BPL criteria, so that has come as a major argument. Now equality of opportunity की बात करें, so there was a case study in M. Nagaraj versus Union of India which happened in 2006, Constitutional bench, it ruled that equality is a part of basic structure doctrine of the constitution. So what is the criteria of equality of opportunity? Here it is being argued that the reservations should be scrapped altogether. Also, if you keep on providing reservations, this is ultimately going to pose a burden on the state exchequer, and ultimately the burden is going to fall on the taxpayers' pocket. Hard working class, taxpayers' profit, who do not get the benefits, who do not get an equal level playing field in when it comes to your job section or your reservation section, but they have to bear the brunt of the practices that have been adopted by the government, right? Now there are a couple of related provisions in the constitution. One more major debate that has come out of this EWS quota, reservation quota, is how does equality of opportunity is being compared with your capability. How basically the reservation works is, if you consider as a student, if someone who falls under ST category, OBC category, SC category, if we consider UPSC itself, their age limit is more and their attempt limit is either a large number of attempts as compared to the general category, or there is no limit on attempts, right? Whereas for the general category people, the cutoff marks are the highest. Also, they have no relaxation neither in the age limit nor in the number of attempts, right? Now, how does someone who competes in the general category, who has scored more marks, is equivalent to someone who falls in the SC category, has scored lesser number of marks, right? So this is one of the burning topics that have come that has been in limelight already. Also, if you add economically weaker section quota to that particular number of reserved seats available, how does it play fair to the general category people? This is one of the most argued questions that have come in the recent times, right? So this needs to be addressed. Now, if we talk about the related provisions in the constitution, Article 16 part 1 and part 2, then Article 15 part 1, Article 15 part 4 and 16 part 4, and Article 16 part 4a. These are the basic related provisions in the constitution which have been inserted particularly for these sections of the society. I hope you guys know what these sections are. If not, please look them up and try including them in your answers, right? So this is something, this basic structure doctrine has been a burning debate, and please try to cover all the other aspects which are related to this particular topic, right? Now I hope you guys do not have any doubt related to this topic. Now let's come to our second topic for today. Our second topic for today is age of consent for adolescents. So now this is a very sensitive topic which has been in news. Basically this has been in news because, see, the legal marriage age, what is the legal age of marriage for a boy and a girl? If someone can mention it in comments. Good afternoon everyone. What has been set as the legal marriage age for a girl and a boy, or a man and a woman? Okay, Nisar. And for a man? Hello everyone. Can you just answer? Okay, 21 for the boys. Now the point is, see, if you're getting married before this age, this is a criminal offense. But there is no as such determined age for having consensual sex before marriage. And see, under POSCO, if you are under 16 years of age, it is a criminal offense, whether you have consent of the concerned person or not. But there are two aspects which come into play here when we talk about polity. These are voidable circumstances and void circumstances. So the age group below 16 years of age comes under your void circumstances, where this is a criminal offence altogether. But the age group between 16 to 18 years, if you have the consent of the girl or the said boy for sexual relationships, for penetrative intercourse practices, then this comes under your voidable category. And in some cases, depending upon the charges filed, depending upon the conditions, this might be or might not be a criminal offence. And recently something happened and Karnataka High Court has come up with a strict ruling. And what is it? We are going to discuss now. Recently Karnataka High Court said that the Law Commission of India, they would have to rethink the age criteria in case of age for consent. Age for consent here means having sexual relationships before in between 16 to 18 years of marriage. Particularly in India, because we have this patriarchal society, so it follows majorly for women, but the law is equal for both men and women. So both people who become victims to these sort of false accusations or are convicted wrongly, basically for them the Law Commission of India must intervene and must revisit the whole age criteria thing in this case. Right now, what has happened is, recently Karnataka High Court received a case and they dismissed the case under the Protection of Children from Sexual Offences, popularly known as POCSO Act. Okay, POCSO Act of 2012. They stated that the aspect of consent by a girl of 16 years but whose age is below 18 years, this would have to be considered if it is under POCSO Act. The concept I told you under voidable and void circumstances. Right now, if we talk about the POCSO Act, the offender is usually booked under the section of 366 of IPC. See, if the person is booked for rape against minor, okay, basically it comes under your crime against children, and the people who are at default, the criminal who is at default is booked under section 366 of IPC, section 6 of the POCSO Act and section 9 of Prohibition of Child Marriage Act of 2006. Also under POCSO Act of 2012. POCSO Act of 2012, under several provisions of IPC, whoever commits a penetrative sexual assault on a child, anyone who is below 18 years of age can be imprisoned for a term which is less than 7 years. Also, this could be for life, along with having some sort of fine in depending upon the case and depending upon the level of crime has happened, whatsoever the punishment is, which is decided by the concerned authorities. Now, even if the girl is 16 years old, she is considered as a child under POCSO Act, hence her consent does not matter. The consent ka under POCSO, the whole concept of the consent under POCSO Act is void, and any sexual intercourse is treated as rape, thus opening it up, thus it comes under your category of stringent punishment. Now, what are the major concerns with age of consent aspect which has come into limelight is there has been a constant misuse of law. Okay? People usually who are not okay with their sons and daughters being in a relationship falsely accuse one of the parties under this act and they are charged. Also, if there is caste prejudice about it, there is a caste angle in it, this has been seen that this act has been used up very prominently, and in recent years there has been a constant debate about this whole love jihad thing. Okay? So there also this act has come into play very prominently. So mostly what is seen is the disgruntled parents, they file a case basically to foil a relationship between two adolescents. Here a very important case study came in 2021 which was known as Vijay Lakshmi versus state rep case. Now in Madras High Court, what happened? While dismissing your POCSO case, they said the definition of a child under section 2nd D of POCSO Act can be redefined as 16 instead of 18. So various states have various different categories of renaming children, and Madras High Court has given its stand, whereas Karnataka High Court recently dismissed it. Hence, Law Commission needs to revisit it, and we need a unified law and much more clarity over the subject. Now here the court also suggested that the age difference in the consensual relationships should not be more than 5 years. Okay, this should not be more than your 5 years. Now basically, if you see popularly why girls run away to marry, now there are many adolescent realities here in socio-legal responses in India, to the socio-legal responses in India. So there was a study which was published by Partners for Law and Development in 2019, where they made a case for the age of consent to be lower, age of consent to be lower than the age of marriage. Now age of marriage is 18. Here they pushed for the age of consent to be lower than this age, so as to decriminalize sex among older adolescents to protect them from the misuse of law, and sometimes by parents who want to control their daughters, ultimately who want to keep their daughters in check or sons from whoever they want to marry. So now if we talk about way ahead what can be done in this whole process, the government, it needs to look into the issue with the courts and right activists, and there needs to be certain amendments in the various laws, and a homogeneity needs to be made so that even the courts have clarity while giving the verdict, and there are n number of provisions and n number of laws which are in direct conflict with each other. They need to be sorted out so that there is a clarity amongst people what to do and how to proceed further. Now there needs to be an awareness about the laws. Basically, if you go into the lower strata of the society, the illiterate section, not so qualified section, they barely know anything about the laws, and there they are terrorized by the nexus of police, the judicial people who are involved, also the parents. Okay, the nexus which is formed between these three parties, they use it, misuse it, and the innocent people bear the brunt of it. Also, we need to evaluate the constant question that comes up during this whole process, is why we need the legal age of marriage to be increased so that people can make informed choices. Also, the continuous dilemma in which the youth suffers because they are unable to decide. See, there are a lot of changes happening when you are a teenager, you are high on hormones and you do not realize what you actually want, and most of the times people somehow take the benefit out of it. So activists have been pushing it. Recently there have been a lot of debate on it, that the increase of there should be increase in the age of marriage in India. Also, there was a recent article in Hindu about what India is doing to get rid of its child marriage numbers. So there also it might have an impact, because even though child marriage has been deemed illegal, India is one such country who has one of the highest number of child marriages, and innocent lives are caught in the crossfire between the orthodoxy and the modernity, right? So this needs to be addressed as soon as possible. Now let's move to our next topic for today. Now next topic for today addresses our sealed cover affidavits. Now Supreme Court, what it has done, the Supreme Court has suggested a way out of routinely filing documents in sealed covers, especially in the cases which tiptoe around or which revolve around the national security, the concern for the national security. Now before we get started, the basic question needs to be addressed: what is an affidavit? So affidavit is basically a written statement which is made under oath, and it is used in a legal proceeding. Now what a person does is, a person swears to be truthful while creating the affidavit, and whatever is written in the affidavit, it is sworn under oath and then signed by the person who produces the affidavit. And ultimately, why these are required? Because these are an important part of court proceedings. They are a means of a source of a public record, and it gives a written account of everything that has happened, that has been happening, and it makes the whole process of judging, the whole process of going through a case for the judiciary very easy. Now, why this was in news? Now, sealed cover affidavits were in news because Supreme Court was recently urged to consider laying down on law. Laying down on law means scrapping off this whole provision which is adopted by the governments while submitting the affidavits under the sealed cover, by terming that whatever documents are present in that particular affidavit are directly related to the national security. Now, what the law says? The law permits the submission of the material to the submission of confidential material to the courts in some cases in sealed covers. As per Evidence Act also, which we inherited from the British Raj, this also allows the private disclosure of some documents, and hence the court actually has an upper hand in this whole scenario, right? Now, here in some cases where the government insists on keeping materials confidential from petitioners, right, their government has some specific privilege, and the affidavit hence is produced under your hidden category. Now, courts also, court also can order the contents to be kept confidential. See, whatever happens in court is usually a part of public record. Whatever happens, recently court has been pushing for live streaming, live telecast of the whole proceedings. Now, this comes in direct contradiction with the sealed cover affidavits. Now, what Supreme Court has said that instead of keeping the whole document under cover, the whole document hidden, what the government can do, they can redact the sensitive portions out of the document and show the rest to the petitioners, so that the petitioners actually have something to reply to. What happens is, when you produce an affidavit under the sealed cover section, the petitioner does not get to see it, and hence they cannot reply to it. So, there and then itself the case becomes open and shut case altogether, right? Now, if what Supreme Court has opined, if that is done, if the sensitive information is redacted and rest is being produced, it will address both states concerned about national security and the right to know of the petitioners. Now, if you talk about what are the issues with the sealed cover affidavits, it has become a repeated practice where national security is brought up and it is used as a loophole in the courts across the country. And this has been happening repetitively over the various courts, high courts and Supreme Court, in different states and at different times altogether, and usually it happens where the government is involved, where the government is the second party. Now, whenever the question comes of national security, even the courts, they become some sort of the courts, they become biased. There is some sort of tiptoeing around the information, and even the court feels that their hands are tied, so they cannot reveal the information. And if you see in the long run, it proves as unjustful, it proves bias towards the other party of petitioner. Now, if you talk about a recent example, there was a recent decision of the court in which Armed Force Tribunal, which was dealing with the case of a permanent commission in the Navy, they relied on the sealed cover report, and the other side did not get any opportunity to reply to that whole section. So, mostly if the other party of the petitioner is not able to reply, their bail is directly denied, right? Now, as I already told you, sealed covers, they are in directly contradiction with the concept of open courts, where courts have been pushing for larger transparency and direct telecast, live telecast of the whole proceedings, right? They usually, sealed covers are usually used in the disputed cases. For example, your Rafael Jets or Bhima Koregaon case, especially in the NRC cases of Assam, okay, where the government has an upper hand, and as I told you, government usually they usually act as a loophole for the government, right? In these cases, sealed cover even rose to the status of due procedure, and again it also came in direct hindrance with your fairness or justice of the law. If we talk about Indian Evidence Act, so it was originally passed by Imperial Legislative Council in 1872 during your British Raj. Now when India gained independence, the act continued to be forced because we inherited most of the parts from the British Raj, and it contains a set of rules where there are certain rules of admissibility of evidence which are permitted in the court of law. Now if you talk about the significance, the enactment and adoption of Indian Evidence Act was basically a path-breaking judicial measure which was introduced in India, ultimately changed the entire system of concepts. Here what evidence means? Evidence means something which is concrete and which can be produced in the court, which means your affidavits, your electronic data, anything digital data, something which can be cross-verified and which is admissible in the court of law as a proof for a particular act, right? If you talk about what can be done in this whole issue, if you talk about the Western countries, if there is any such kind of material which is in direct contradiction with your arena of national security, the court usually appoints a neutral person to have a look into the matter, and then as per the person assists, the person is usually someone who holds the expertise over the whole topic. So court appoints a neutral person and they accordingly assist the court. Now the main mischief of the sealed cover is this gives the state, the ruling government, to avoid deep scrutiny, and this has to be addressed. Now Supreme Court needs to address this topic suo motu, and we need a proper legislation for this whole topic so that the innocent people who are suffering because of this whole process, they can find a way out, and the whole concept of justifiability, the court being fair, is given a fair chance and a fair trial, right? I hope the topics we discussed today, you guys have heard them, and if you guys have any doubt, you can mention them in comments. I'll try taking them up in next class. Till then, stay tuned and keep learning, keep watching. Thank you so much. Bye bye.